The email arrived at 11:47 p.m. Dr. Marcus Webb sat in his home office in Chapel Hill, North Carolina, grading papers from his constitutional law seminar when his phone lit up. University Administrative Notice. Mandatory meeting 8 a.m. Monday. Your attendance is required. No subject. No context. Just a summons. Marcus had been teaching at Whitmore University for 23 years. He'd seen administrative emails before. This one felt different. The tone was sterile. Clinical. The kind of language institutions use when they've already made a decision and need you present for the formality. He went back to grading, but his pen hovered over the same sentence for 3 minutes before he realized he hadn't read a single word. His wife, Angela, appeared in the doorway holding 2 mugs of tea. You're doing that thing again. What thing? The thing where you pretend you're fine but your jaw's so tight I can hear your teeth grinding from the kitchen. Marcus set down his pen. 29 years of marriage had made lying to her pointless. Got a meeting Monday. Don't know what it's about. Angela handed him the tea and leaned against his desk. They finally promoting you to department chair? Doubt it. Marcus took a sip. The tea was too hot. He drank it anyway. Timing's wrong. And they would have called, not sent a midnight email. Then what? That was the question that kept him awake until 3 a.m., staring at ceiling cracks he'd memorized years ago, running through every interaction of the past semester. Every lecture. Every office hour. Every faculty meeting where he'd pushed back against policies he knew were wrong. 23 years at Whitmore. Tenured professor. Published author. Former department chair. Awards lining his office walls. Students who'd gone on to argue before the Supreme Court, who sent him Christmas cards thanking him for changing their lives. But that email sat in his inbox like a ticking clock. Monday morning came cold and gray. March in North Carolina, that unstable season where winter refused to die. Marcus dressed carefully. Navy suit. Red tie. The armor of professionalism. Angela kissed him at the door and told him to call her after. He promised he would. The meeting was in Caldwell Hall, 3rd floor, the administrative wing where decisions got made behind closed doors and students never ventured. Marcus had been in that building maybe twice in 2 decades. Once for his tenure review. Once for a donor event he'd been required to attend. He arrived at 7:52 a.m. The receptionist, a young woman he'd never seen before, directed him to conference room C without making eye contact. The room was smaller than he expected. Oval table. 6 chairs. No windows. Fluorescent lights humming overhead with that persistent buzz that meant someone should have replaced them months ago. 3 people were already seated. Dean Patricia Holloway. Mid-50s, sharp suit, sharper reputation. She'd been dean for 4 years. Marcus had voted against her appointment. She knew it. Dr. Gerald Simmons. Associate Dean of Faculty Affairs. Bland face, bland voice, the kind of administrator who'd perfected the art of saying nothing with many words. And someone Marcus didn't recognize. White man, early 40s, expensive suit that didn't match the university's usual aesthetic. No name tag. No introduction. Marcus took the remaining seat. Morning. Dr. Webb. Thank you for coming. Holloway's voice carried that false warmth administrators used before delivering bad news. I'll get straight to the point. We've received complaints regarding your classroom conduct. The room tilted slightly. Marcus kept his expression neutral. What kind of complaints? Holloway slid a folder across the table. Thin. Maybe 10 pages. Marcus didn't open it. Not yet. He'd learned in courtrooms and faculty meetings that opening a document too quickly signaled anxiety. Multiple students have reported feeling uncomfortable with certain topics you've addressed in your constitutional law seminar. Specifically, discussions about systemic racism, implicit bias in legal systems, and historical injustices. Marcus let the silence stretch. Counted to 5. I teach constitutional law. Those topics are integral to understanding Fourth Amendment applications, 14th Amendment equal protection, voting rights legislation. We understand that. Simmons cut in, his voice modulated to sound reasonable. However, the concern is about the manner in which these topics are presented. Students feel you're advancing a particular political agenda rather than objective legal analysis. Which students? That's confidential. How many students? Pause. Simmons glanced at Holloway. 4 formal complaints. Marcus did the math instantly. He taught 47 students across 2 sections. 4 complaints represented 8.5% of his classes. And the other 43 students? Have they been surveyed? Dr. Webb, this isn't about numbers. Holloway's warmth was evaporating. Even one student feeling marginalized in your classroom is concerning. Marginalized. Marcus tasted the word. Bitter. Ironic. Students of color have been marginalized in legal education for generations. I teach them the truth about how constitutional principles were applied selectively based on race. If that makes someone uncomfortable, perhaps they should examine why. The unnamed man spoke for the first time. His voice was smooth, practiced. Dr. Webb, nobody's questioning your credentials or your tenure. What we're suggesting is a voluntary adjustment to your curriculum. Focus more on doctrinal analysis, less on socio-political commentary. Keep the classroom neutral. Neutral. Marcus leaned back. 23 years of teaching, and someone in an expensive suit who'd never graded a constitutional law exam was telling him how to structure his course. There's no such thing as neutral when teaching law that was written by slave owners and applied by judges who upheld segregation. Pretending otherwise isn't neutral. It's erasure. This attitude is exactly what concerns us. Holloway's mask dropped completely. You're being offered an opportunity to address these complaints voluntarily. Adjust your teaching approach. Submit revised syllabi for review. Continue your career without incident. Marcus heard the unspoken second half of that sentence hanging in the air like smoke. Or else. And if I decline this opportunity? Simmons cleared his throat. The university would be forced to conduct a formal investigation. Interviews with students. Review of recorded lectures. Assessment of your pedagogical methods. Could take months. Be very disruptive. Marcus opened the folder then. Scanned the complaints. Generic language. Made students feel attacked for their heritage. Pushed a divisive racial narrative. Created a hostile environment for non-minority students. The complaints were dated within a 3-week span. February 14th through March 3rd. All submitted after Marcus's lecture on Brown versus Board of Education and its incomplete implementation. He'd taught that lecture for 23 years. It had won him teaching awards. This year it had apparently crossed a line. Marcus closed the folder. Slid it back across the table. I need time to consider. We need an answer by end of business Friday. Holloway stood, meeting over. We're trying to help you, Dr. Webb. I hope you recognize that. Marcus walked out of Caldwell Hall into morning air that felt thinner than when he'd entered. Students crossed the quad carrying backpacks and coffee cups, moving through their Monday with no idea that inside that building, someone's career was being dissected with surgical precision. He sat in his car for 11 minutes before calling Angela. She answered on the second ring. How bad? They want me to change how I teach. Make it more neutral. He could hear the quotation marks in his own voice. What did you tell them? That I'd think about it. A long pause. Angela knew him too well. But you're not going to comply. How can I? Marcus watched students file into the liberal arts building where he'd be teaching in 90 minutes. Everything I teach is documented history. Supreme Court cases. Congressional records. If they want me to pretend institutional racism doesn't exist in legal frameworks, they're asking me to lie. They're giving you an exit ramp, Marcus. I know. And you're not taking it. Would you? Another pause. When Angela spoke again, her voice carried that steel he'd fallen in love with 3 decades ago. No. But I'm not the one who has to walk into that classroom knowing they're watching. Marcus taught his 10 a.m. section on autopilot. Criminal procedure. Fourth Amendment search and seizure. He covered Terry stops, reasonable suspicion, the way stop and frisk policies had been applied disproportionately in minority communities. Statistics. Court rulings. Facts. 3 students in the back row kept their phones visible the entire class. Recording? Taking notes? Reporting back to someone? Marcus didn't alter a single word of his lecture. That night he sat with Angela at their kitchen table and made a list. Not of what he'd done wrong but of what he knew was coming. Formal investigation. Selective evidence gathering. Character assassination disguised as concern. He'd seen this pattern before. Watched it happen to colleagues who'd challenged the wrong people or taught the wrong truths. The machine didn't destroy you quickly. It was methodical. Death by 1,000 procedural cuts. But Marcus had something those other professors hadn't. Documentation. For 23 years Marcus Webb had kept copies of everything. Every syllabus. Every lecture outline. Every student evaluation. Every published article. Every award. Every email exchange with administration. Not because he was paranoid. Because he was Black. His father had taught him that lesson at age 12, sitting at this same kitchen table in a different house. Son, you're going to have to be twice as good to get half as far. And you better keep receipts for every single step because they'll try to say you were never there. His father had been a postal worker for 40 years. Kept every performance review in a filing cabinet in the basement. Never needed them, but he kept them anyway because being prepared wasn't paranoia when history proved you right. Marcus had inherited that filing cabinet. Filled it with his own receipts. Now he was going to need every single one. If you're watching this right now, drop a like and hit subscribe. My mother told me I wouldn't even reach 1,000 subscribers with these stories. But I believe what happened to Dr. Webb deserves to be heard. Help me prove that these tales matter. The formal investigation notice arrived Thursday. Expedited timeline. Interviews scheduled. Marcus's lectures would be reviewed by a pedagogical assessment committee, whose members wouldn't be disclosed for confidentiality reasons. Marcus hired a lawyer Friday. Catherine Reeves. Civil rights attorney. 48 years old. Built her career dismantling institutional discrimination disguised as policy. She'd sued 3 universities already. One every time. They met in her office downtown, floor-to-ceiling windows overlooking Chapel Hill. Marcus brought his filing cabinet. Metaphorically. 3 boxes of documentation spanning 23 years. Catherine spent 4 hours reviewing materials. Didn't speak much. Just read, occasionally making notes on a yellow legal pad. Finally, she looked up. They're not actually investigating your teaching. Then what are they investigating? You. Catherine tapped her pen against the legal pad. These complaints are pretextual. Generic language submitted in a cluster, strategically timed after your most critical lectures on race and law. This isn't about pedagogy. It's about silencing you. Why now? I've been teaching this material for 2 decades. Because something changed. Catherine pulled out her laptop, started typing. New dean. New donor pressure. Political climate. Could be any combination. But someone wants you gone and they're building a paper trail to justify it. Marcus felt something cold settle in his chest. Can they do that? I'm tenured. Tenure isn't invincible. It's protection, not immunity. If they can document a pattern of pedagogical misconduct, create enough complaints, manufacture a hostile environment narrative, they can initiate termination proceedings. Catherine looked at him directly. But here's what they didn't count on. You kept evidence. Will that be enough? Depends on how far you're willing to go. Marcus thought about his students. The ones who'd thanked him for teaching them truth instead of sanitized history. The Black and brown students who'd told him his classes were the first time they'd seen themselves in constitutional law discussions. The white students who'd had their assumptions challenged and grown from it. He thought about his father's filing cabinet. About receipts kept for moments exactly like this. How far do we need to go? Catherine smiled. Not warmly. Strategically. All the way. The university's investigation proceeded with bureaucratic efficiency. Interviews scheduled. Evidence requests submitted. Marcus was placed on administrative leave, pending the outcome. Paid but barred from teaching. His classes were reassigned to adjunct professors who promised to maintain academic neutrality. Marcus spent his forced sabbatical doing research. Not for his defense, though Catherine handled that. Research into Whitmore University's patterns. He requested student demographic data through his attorney. Enrollment statistics. Faculty hiring records. Disciplinary actions. The university fought every request citing privacy concerns, but Catherine was relentless. Patterns emerged. Black faculty at Whitmore. 6% of total staff. National average, 6%. So far unremarkable. Black faculty who achieved tenure, 2.3%. National average, 4.1%. Black faculty who'd faced disciplinary investigations in the past decade. 11 out of 14. Percentage, 78.5%. White faculty who'd faced similar investigations. 8 out of 186. Percentage, 4.3%. Marcus stared at the numbers on his screen until they blurred. This wasn't about him. It had never been about him. He was just the latest name in a pattern so obvious, so documented, that its invisibility required institutional effort. Catherine filed a discrimination complaint with the Department of Education's Office for Civil Rights. 37 pages. Meticulously documented. Statistical evidence. Pattern and practice claims. Individual anecdotes from other Black faculty who'd faced similar targeting. The university's response was swift and predictable. Deny everything. Characterize Marcus's claims as a disgruntled employee attempting to weaponize race to avoid legitimate accountability. Then they made a mistake. In their official response, the university's legal team referenced an internal memo from 2019. A memo discussing strategies to manage faculty who inject political bias into curriculum. The memo specifically mentioned Marcus by name. Referenced his problematic focus on racial issues in constitutional interpretation. That memo predated any student complaints by 4 years. Catherine read it 3 times. Then called Marcus. They documented their intent to target you years before manufacturing justification. Can we use that? We can destroy them with it. The hearing was scheduled for September. University Appeals Board. 3 faculty members, 2 administrators, 1 outside legal expert. Marcus would present his defense. The university would present its case. A decision would follow. Marcus prepared like he was arguing before the Supreme Court. He compiled every lecture he'd ever given on race and constitutional law. Showed how each one was grounded in established legal precedent. Supreme Court cases. Congressional testimony. Scholarly consensus. He gathered student evaluations from 23 years. Over 1,200 individual assessments. Average rating, 4.7 out of 5. Comments consistently praised his rigor, his fairness, his ability to challenge assumptions while respecting disagreement. He documented every teaching award, every published article, every conference presentation, every doctoral student he'd mentored to completion. And he prepared to tell them exactly what this was really about. The hearing room was smaller than a courtroom but felt just as heavy. September morning. Late summer heat pressing against windows that didn't open. The panel sat at an elevated table. Marcus and Catherine sat below, literally and figuratively positioned as supplicants awaiting judgment. Dean Holloway presented the university's case first. Professional. Measured. She outlined the complaints. Discussed the importance of inclusive learning environments. Stressed that this wasn't about Marcus's race or scholarship, but about pedagogical approach. She showed clips from his lectures. Carefully edited. Moments where Marcus discussed slavery's influence on constitutional drafting, where he analyzed racial gerrymandering, where he explained how facially neutral laws produced racially disparate outcomes. Out of context, stripped of legal framework, his words sounded like political advocacy instead of legal analysis. Then Catherine stood up. She didn't speak immediately. Let the silence build. Then she placed a document on the overhead projector. The 2019 memo. The one targeting Marcus by name. The one proving premeditation. This memo was written by Associate Dean Simmons in March 2019. 4 years before any student complaints were filed. It identifies Dr. Webb as problematic. It suggests strategies for managing him. It uses phrases like, neutralize his influence, and create documentation trail for potential action. Catherine let that sit. The complaints you're reviewing today weren't organic student concerns. They were solicited, encouraged, manufactured as justification for a decision this university made 4 years ago. She pulled out more documents. Emails between administrators and certain students. Suggestion that they attend Marcus's lectures specifically to identify problematic content. Promises of academic support if they filed formal complaints. The panel members shifted uncomfortably. Catherine wasn't done. She presented the statistical analysis. The targeting of black faculty at rates 17 times higher than white colleagues. The pattern of investigations that followed the same script. Vague complaints. Pedagogical concerns. Suggestions to adjust teaching approach. Then when faculty refused to self-censor, formal disciplinary action. This isn't about Dr. Webb's teaching. This is about controlling what black professors are allowed to say about race in American law. This is about erasing uncomfortable truths from curriculum because they challenge the institution's preferred narrative. Catherine placed one final document on the projector. A letter. Signed by 89 of Marcus's former students. Lawyers now. Public defenders, prosecutors, judges, civil rights advocates, corporate attorneys, academics. Every one of them writing to defend the professor who taught them to think critically about law's relationship with justice. One letter stood out. Written by Judge Raymond Foster, federal appellate judge for the Fourth Circuit. He'd been Marcus's student in 1998. Dr. Webb taught me that law is a tool. Like any tool, it can build or destroy depending on who wields it and why. He taught me to examine legal history honestly, including its failures and biases. That education made me a better attorney and a better judge. Any institution that punishes a professor for teaching historical truth is an institution that has lost its way. The hearing lasted 6 hours. By the end, 2 of the panel members weren't making eye contact with Dean Holloway. The decision came 3 weeks later. Unanimous. The university's investigation was deemed procedurally flawed. The complaints against Marcus were found to lack merit. He was fully reinstated. Awarded back pay for his administrative leave. Issued a formal apology. But Marcus knew it wasn't over. He'd won the battle. The war was still raging. Marcus returned to teaching in October. His classroom was packed. Students who'd heard about the case. Students who wanted to see the professor the university had tried to silence. Students who needed to know that speaking truth still mattered. His first lecture back was on Brown versus Board of Education. The same lecture that had triggered the original complaints. He didn't change a single word. Halfway through, a student in the third row, white kid, baseball cap, raised his hand. Dr. Webb, do you think universities today are still segregated? The question hung in the air. Loaded. Dangerous. The kind of question that could reignite everything. Marcus thought about the answer the university would want him to give. The safe answer. The neutral answer. Then he thought about his father's filing cabinet. About receipts kept for moments when truth mattered more than comfort. Yes, Marcus said simply. Not by law. But by economics, by geography, by opportunity gaps that mirror the same racial lines legal segregation drew. Different mechanisms. Same outcomes. That's why studying constitutional history matters. The fights we think we've won are often just wars in temporary ceasefires. The student nodded. Wrote it down. 20 other students did the same. No complaints were filed. But Marcus knew they were still watching. Catherine called him in November. We need to talk about next steps. I'm reinstated. What next steps? The pattern we uncovered doesn't end with you. Other black faculty are still being targeted. The system that tried to remove you is still functioning. We exposed one operation. The machine is still running. What are you suggesting? A lawsuit. Not just against the university for what they did to you. A civil rights action challenging their pattern and practice of discriminating against black faculty. We have the documentation. We have the statistical evidence. We can force systemic change. Marcus sat in his office, surrounded by books and awards and memories of 23 years. He was exhausted. The hearing had drained something from him he wasn't sure he could refill. The idea of more legal battles, more investigations, more exposure felt like drowning. But he thought about the other names in Catherine's database. The black professors who'd been quietly pushed out. The ones who'd accepted buyouts to avoid investigations. The ones who'd left academia entirely rather than fight. He thought about his students. The ones who needed professors willing to tell them truth. The ones who deserved to learn from faculty who looked like them. How long would a lawsuit take? 2 years minimum. Could be longer. Discovery will be brutal. They'll come after you personally. Your reputation. Your publications. Every lecture you've ever given. They'll try to make you the problem instead of the symptom. And if we win? Policy changes. Mandatory bias training. Independent oversight of disciplinary procedures. Financial penalties. Public accountability. Catherine paused. And precedent. Other universities watching will think twice before pulling the same tactics. Marcus looked at his father's photograph on his desk. Postal worker who kept receipts for 40 years. Never needed them. Kept them anyway. File it. The lawsuit was filed December 15th. Dr. Marcus Webb et al. v. Whitmore University. Class action. 9 black faculty members as plaintiffs. Each one with their own story of investigations, complaints, disciplinary actions that followed suspicious patterns. The media coverage was immediate. Local news. National outlets. Academic journals. Inside Higher Ed ran a feature story. The Chronicle of Higher Education published an investigative piece on racial discrimination in faculty disciplinary procedures. Whitmore's response was aggressive. They hired a major law firm. Issued statements about their commitment to diversity. Pointed to their minority recruitment initiatives. Suggested the plaintiffs were disgruntled employees misusing civil rights law. Discovery began in February. Catherine requested everything. Email archives. Faculty meeting minutes. Disciplinary records. Demographic data. Performance evaluations. Hiring decisions spanning 2 decades. The university fought every request. Claimed privacy protections. Executive privilege. Academic freedom. Each objection added weeks to the timeline. But documents leaked. Always did. Staff members with consciences. Administrators who'd witnessed the targeting and stayed silent out of fear. Anonymous envelopes appearing at Catherine's office with internal memos. Emails discussing specific faculty members. Strategy documents outlining how to manage problematic voices. One email thread was particularly damning. Between Dean Holloway and the unnamed man from Marcus's initial meeting, whose identity was finally revealed. Richard Brennan. Major donor. Real estate developer. Trustee emeritus. In the emails, Brennan discussed his concerns about Whitmore's leftward drift. Specifically mentioned professors, who make white students feel guilty about their heritage. Suggested that administrative action might be necessary to restore balance. Holloway's responses were careful but complicit. Reassured Brennan that certain faculty were being monitored. That corrective measures were being explored. Marcus's name appeared in 6 separate emails. Catherine filed an amended complaint. Added Brennan as a defendant. Expanded the case to include donor influence on academic freedom. The university's settlement offer came in May. Confidential. 7 figures split among the plaintiffs. No admission of wrongdoing. NDAs required. Catherine forwarded it to Marcus without comment. Marcus called an emergency meeting with the other plaintiffs. 9 people sitting in Catherine's conference room. Different departments. Different stories. Same pattern. Dr. Aisha Thompson, chemistry professor. Targeted after publishing research on environmental racism's health impacts. Dr. James Liu, economics professor. Investigated after teaching modules on racial wealth gaps and slavery's economic legacy. Dr. Carmen Rodriguez, history professor. Disciplined for assigning readings about immigration policy and racial exclusion. 9 people. 9 careers damaged. 9 fights they hadn't chosen but couldn't avoid. Marcus spoke first. They're offering us money to disappear. How much? Dr. Thompson asked. Catherine named the figure. The room went quiet. Dr. Liu broke the silence. That's enough to pay off my daughter's student loans. To refinance my house. To actually retire someday instead of teaching until I die. I know. Marcus understood. Money wasn't nothing. Money was survival. Security. The ability to stop fighting. But if we take it, Dr. Rodriguez said softly, nothing changes. They pay us to be quiet. And next year there's another black professor in another meeting being offered another chance to adjust their teaching. We can't save everyone, Dr. Thompson said, but her voice lacked conviction. No, Marcus agreed. But we can create precedent. We can make it expensive enough that other universities think twice. We can get our names on a ruling that proves what we all know happened. The vote was unanimous. They rejected the settlement. The trial was scheduled for September. Federal Courthouse in Raleigh. Judge Margaret Chin presiding. Stern reputation. No tolerance for nonsense from either side. Catherine spent the summer building their case. Witness lists grew. Expert testimony lined up. Statistical analysts, educational psychologists, civil rights historians, former faculty members willing to testify about their own experiences. The university assembled an equally impressive defense. White shoe law firm, jury consultants, media strategists, but they made a critical error in jury selection. They assumed they wanted conservative jurors, people who might be skeptical of discrimination claims, who might view the plaintiffs as overly sensitive. What they got instead was a jury that included 3 public school teachers, 2 small business owners who'd faced their own struggles, a retired factory worker whose daughter was a public defender, a librarian who'd watched her own institution struggle with diversity, people who understood what institutional power looked like when it moved against individuals. Opening statements began on a Tuesday. 90-degree heat outside. Air conditioning struggling inside. The university's attorney presented their case cleanly. This was about maintaining academic standards, about responding to legitimate student concerns, about faculty who'd refused to accept constructive feedback and then weaponized their race when held accountable. He was smooth, professional, almost convincing. Then Catherine stood up. She didn't start with statistics or evidence. He started with a question. How many chances does someone deserve to prove their competence? Dr. Marcus Webb has been teaching for 23 years. He's won 4 teaching awards, published 2 books, mentored 16 doctoral students to completion, maintained a 4.7 out of 5 student evaluation average over 2 decades. At what point does his record speak for itself? She paused. Let the jury consider. The defense will tell you this case is about accountability. They're right, but not the accountability they mean. This is about holding institutions accountable when they target faculty for teaching uncomfortable truths, when they manufacture complaints to justify predetermined conclusions, when they apply disciplinary procedures selectively based on race. Catherine presented the evidence methodically. The statistical analysis showing black faculty investigated at 17 times the rate of white colleagues. The internal memos discussing specific professors by name. The email threads with donors. The solicited complaints. The university's witnesses contradicted themselves. Dean Holloway claimed investigations were always merit-based, then couldn't explain why the merit threshold seemed to shift depending on faculty race. Associate Dean Simmons insisted the 2019 memo targeting Marcus didn't represent institutional bias, then struggled to explain why similar memos existed for 6 other black professors. Richard Brennan was the breaking point. Called to testify about his donor influence, he attempted to position himself as a concerned alum who simply wanted educational excellence. Catherine destroyed that narrative with his own emails. Mr. Brennan, in this email from February 2019 you wrote, and I quote, "We can't let these professors turn our university into a social justice factory. White students shouldn't be made to feel like perpetrators." Did you write that? Context matters. Yes or no? Did you write those words? Yes, but... And in this email, you suggested that administrative pressure be applied to certain faculty members. Did you provide names? Pause. Brennan's attorney looked uncomfortable. Yes. How many of those names were black faculty? I don't recall. Catherine displayed another document. The list. 9 names. All black professors. All plaintiffs in this case. Does this refresh your memory? The jury's expressions shifted. Not dramatically. Just small movements. A tightening around eyes. A subtle lean forward. The kind of nonverbal cues that attorneys learn to read. They saw it. The pattern. Expert testimony reinforced what the documents revealed. Dr. Keisha Williams, education policy researcher from Harvard, presented findings about racial disparities in faculty disciplinary actions across American universities. Whitmore's numbers weren't just bad. They were among the worst in the nation. The trial lasted 3 weeks. Testimony from 32 witnesses. Over 200 exhibits. Hours of expert analysis. Closing arguments came on a Friday. Summer fading into early fall. The kind of September day that promised change. The university's attorney made a final appeal. This was about academic freedom. about institutional autonomy, about not letting disgruntled employees dictate policy through litigation. Catherine's closing was simpler. The defense wants you to believe this case is complicated. It's not. 9 professors. All black. All targeted for teaching subjects that made powerful people uncomfortable. All subjected to investigations that white colleagues didn't face for identical conduct. That's not academic freedom. That's discrimination. And it's illegal. The jury deliberated for 11 hours across 2 days. When they returned, none of them looked at the defense table. Verdict: unanimous for the plaintiffs on all counts. Pattern and practice of racial discrimination in faculty disciplinary procedures. Proven. Violation of Title VII. Proven. Retaliation. Proven. Damages: $23.4 million. The courtroom erupted. Not with cheers but with something quieter and deeper. Exhaled breath. Released tension. The sound of people who'd been holding themselves together finally allowing themselves to break. Marcus sat perfectly still. Angela gripped his hand. Catherine's expression remained professional but her eyes were wet. Judge Chin read the verdict without editorial comment. Professional. Clinical. But as she dismissed the jury she added something off script. This court thanks the jury for their service in a case that required careful consideration of complex issues. Your diligence is appreciated. It was standard language. But the way she looked at the plaintiffs when she said it made it clear she knew exactly what had been at stake. Outside the courthouse, media waited. Cameras. Microphones. Reporters shouting questions. Catherine handled it. Professional. Measured. This verdict sent a message that institutions couldn't hide discrimination behind policy. That patterns mattered. That documentation won cases. Then she stepped aside and let Marcus speak. He'd prepared remarks. Legal language. Grateful for justice. Hopeful for change. He abandoned all of it. My father kept a filing cabinet full of receipts. Performance reviews from 40 years as a postal worker. He never needed them. But he kept them anyway because he knew that being black in America meant always having to prove you belonged. Always having to document your competence. Always having to be twice as good to get half as far. Marcus looked at the cameras. Knew his students would be watching. Knew other professors facing similar targeting would see this. I don't want my children to inherit that filing cabinet. I don't want the next generation of black scholars to have to keep receipts like I did. This verdict isn't about money. It's about changing a system that demands we prove our worth every single day while others have their competence assumed. It's about making institutional racism expensive enough that universities stop protecting it. The questions kept coming but Marcus was done. He walked to his car with Angela, Catherine trailing behind to handle the press. They drove in silence for 10 minutes before Angela spoke. Your father would be proud. Marcus thought about that filing cabinet. About all the receipts that had seemed paranoid until the moment they were essential. I hope so. The money from the verdict funded several initiatives. Marcus and the other plaintiffs established a legal defense fund for faculty facing discrimination. Created a database tracking disciplinary actions across universities to identify patterns early. Funded scholarships for students from marginalized communities pursuing legal education. They also funded something more personal. A complete archive of the case. Every document, every email, every piece of evidence, made publicly available online. Searchable. Accessible to any faculty member, any student, any researcher who needed to understand what institutional discrimination looked like when it hid behind policy. Whitmore University underwent mandatory reforms. Independent oversight of disciplinary procedures. Demographic reporting on investigations. Anonymous complaint mechanisms for faculty. Bias training for all administrators. Dean Holloway resigned 3 months after the verdict. Took a position at a private consulting firm. Associate Dean Simmons followed. Richard Brennan quietly removed himself from the board of trustees. None of them admitted wrongdoing. They simply moved on the way powerful people do when accountability arrives. Marcus returned to teaching. His classes remained full. Students still challenged him. He still pushed back with evidence and precedent and a refusal to sanitize history. But something had shifted. Other black faculty at Whitmore reported changes. Fewer arbitrary investigations. More support for research on race and inequality. A slowly increasing sense that they could teach without constantly looking over their shoulders. It wasn't perfect. Systems don't transform overnight. But it was movement. 2 years after the verdict, Marcus was invited to speak at a national conference on academic freedom. The audience was packed with faculty who'd faced similar targeting, who'd kept their own receipts, who'd been told to be more neutral, more careful, more quiet. He told them about his father's filing cabinet, about documentation as resistance, about the difference between winning a case and changing a culture. The verdict matters, Marcus said. But what matters more is what you do with it. Every time you teach truth instead of comfort. Every time you refuse to sanitize history to make powerful people feel better. Every time you document, preserve, and share evidence of institutional bias. That's when change happens. A young professor, black woman, maybe 30, raised her hand. Dr. Webb, what do you say to faculty who can't afford to fight? Who need their jobs? Who have families depending on them? Marcus thought about that question for a long time. Because it was the right question. The hard question. The one that acknowledged that courage was a privilege not everyone could afford. I say document anyway. Keep receipts even if you never use them. Build networks with other faculty facing the same targeting. Share information. Create collective knowledge. Because sometimes the fight isn't yours to finish. Sometimes you're just laying groundwork for the person who comes after you. He paused. And I say that you're allowed to survive. Taking a buyout or accepting a settlement or leaving academia entirely doesn't make you a failure. Sometimes the system is designed to break you, and refusing to be broken means choosing your mental health, your family, your future. That's not surrender. That's survival. And survival is its own form of resistance. The room went quiet. Not uncomfortable silence. Acknowledged truth. After the conference, the young professor approached him. I'm being investigated right now. Same pattern you described. Complaints about my African American literature course being too political. I'm terrified. Marcus didn't offer false comfort. You have a lawyer? Can't afford one. You can now. Marcus handed her a card. The legal defense fund they'd established. Call them. They'll connect you with representation. They'll help you document. You're not alone in this. The professor's eyes filled. Thank you. Don't thank me. Just promise me something. What? When you win, and you will win, help the next person. That's how we change this. One case at a time. One professor refusing to be silent at a time. She promised. Marcus drove home that night thinking about patterns. About how institutional discrimination worked through repetition. Targeting one person, then another, hoping each would feel isolated enough to give up. But he also thought about counter patterns. Networks of resistance. Collective documentation. Professors helping professors. Students supporting faculty. Courts occasionally, imperfectly, delivering justice. Angela was waiting when he got home. How was it? Exhausting. Necessary. Marcus collapsed onto the couch. Met a young professor being targeted. Same script. Same tactics. Did you help her? Connected her with the fund. Told her to document everything. Angela sat beside him. You can't save everyone, Marcus. I know. But I can make sure they have better odds than I did. Silence settled. Comfortable. The kind that came from 3 decades of marriage and shared battles. Your father would be proud, Angela said again. Second time since the verdict. She only repeated herself when something was true enough to need saying twice. Maybe. Marcus thought about that filing cabinet now passed to him, now filled with his own receipts. Or maybe he'd just say, this is what you do. You keep your receipts. You fight when you can. You survive when you can't. You help the next person. That's the work. Is it ever finished? No. Marcus said it without sadness. Just fact. The work's never finished. But it gets a little easier for the people who come after. That's the point. 5 years later. Dr. Janice Webb graduated from law school in May. Top of her class. Marcus and Angela sat in the audience watching their daughter receive her degree. She'd chosen law because she'd grown up watching her father fight. Had seen what happened when someone with credentials and documentation and refusal to be silent took on institutional power. During her graduation speech, student speaker, she told the story without naming names. About a professor who'd been targeted for teaching truth. who'd fought back and won, who'd proven that justice wasn't guaranteed but could be claimed. She didn't need to name him. Everyone in that auditorium who mattered already knew. After the ceremony, Janice found Marcus. "I'm joining Catherine's firm. Civil rights work. Faculty discrimination cases." Marcus felt something catch in his throat. Pride. Fear. The complicated emotions of watching your child choose a hard path because you showed them it was possible. "It's brutal work, baby girl. I know. You taught me that." Janice smiled. "You also taught me it matters. That documentation wins cases. That patterns can be proven. That institutions can be held accountable. And when they try to break you, I keep my receipts." Janice said it simply. "Just like Grandpa. Just like you." That night, Marcus sat in his home office. The filing cabinet had grown. Now it contained not just his documentation, but shared files from other professors. Evidence pooled across institutions. Patterns identified. Networks built. His phone buzzed. Email from a professor at another university. Different state. Same story. Being investigated for teaching critical race theory in a legal ethics class. Didn't know what to do. Marcus forwarded the email to the Legal Defense Fund. Sent a personal message offering to talk. Attached resources about documentation and legal rights. Then he opened a new folder on his computer. Started a document titled, "Best Practices for Faculty-Facing Disciplinary Investigations." He wrote until midnight. Drew on his experience. Catherine's legal strategy. Lessons from 2 years of litigation. Advice he wished he'd had in that first meeting with Dean Holloway. When he finished, he uploaded it to the public database. Made it searchable. Free. Available to any professor who needed it. Angela appeared in the doorway with tea. "You're doing it again." "What?" "Saving people you've never met." Marcus took the tea. Still too hot. Drank it anyway. "Someone saved me, Catherine." The former students who wrote letters. The other plaintiffs who refused to settle. "Now it's my turn." "Your turn ever end?" Marcus thought about his father. About that postal worker who kept receipts for 40 years. Who taught him that being prepared wasn't paranoia when history proved you right. "No," Marcus said honestly. "But it gets easier to carry when you're not doing it alone." He looked at the document he'd just uploaded. Imagined professors he'd never meet reading it. Using it. Fighting back. Winning their own cases. Building their own networks. Imagined a future where the filing cabinet wasn't necessary. Where Black faculty could teach without constantly documenting their competence. Where uncomfortable truths could be spoken without fear of manufactured consequences. That future wasn't here yet. Maybe wouldn't arrive in his lifetime. But every case won, every professor helped, every pattern exposed moved it a little closer. Marcus closed his laptop. Finished his tea. Went to join Angela in bed. Tomorrow he'd teach constitutional law. Would talk about Brown versus Board of Education and its incomplete implementation. Would challenge students to think critically about law's relationship with justice. And if someone complained, he had his receipts. If you made it to the end, drop that like and subscribe. My mother said these stories wouldn't matter to anyone. That I'd never build something meaningful telling them. But you watching proves these tales deserve to be heard. Help me show that truth-telling still has power. Share this story. Let people know what happened to Dr. Webb matters. Because here's what they don't tell you about justice. It's not a moment. It's not a verdict. It's not even a victory. Justice is what happens after the cameras leave. When the next person faces the same targeting and knows they're not alone. When patterns get documented so thoroughly they can't be denied. When powerful people realize discrimination is too expensive to hide. Dr. Marcus Webb didn't just win a lawsuit. He built a blueprint. And somewhere right now, another professor is reading his documentation guide. Another faculty member is calling that legal defense fund. Another student is watching their teacher refuse to be silenced and learning what courage actually looks like. That's the real ending. Not the verdict. The ripple. See you in the next one.